Colin O'Keefe checking in here for LXBN TV. The Supreme Court handed down a big ruling this week in EEOC v. Mach Mining, stating that the Commission's conciliation efforts are subject to oversight. Joining me to discuss is our resident EEOC expert, one of the top lawyers in the country in dealing with them, actually filed an amicus brief in this case and was there for the oral arguments. It's Seyfarth Shaw's Jerry Maatman, author on the Workplace Class Action blog. Jerry, thanks as always for joining me, but first off, what exactly happened here? For those of us who aren't fully aware about what went down, can you explain the basics of what happened in the ruling?
Sure. Great to be here, Colin. This case was an ultimate bench slap of the EEOC. It took the position that it is above the law, and whether or not it complies with statutory prerequisites to filing suit, in this instance try to conciliate a claim before filing a lawsuit over it, it took the position that federal district court judges cannot review and cannot look at its conduct. The Supreme Court unanimously rejected that position. Being present for the oral argument on January 13 earlier this year, the Supreme Court reacted in a very hostile way to that particular position of the EEOC, so it was no surprise to me that the court indicated that no, the EEOC, like any other governmental agency that has requirements it must fulfill before it files suit, is of course subject to judicial review as to whether or not it did what it's supposed to do.
That makes sense, yeah. Sometimes the Supreme Court, the justices with the oral arguments, you kind of can't really tell what they're going to do, and then sometimes I assume with the oral arguments they tell you very quickly why they chose to grant cert in the case. So second, what's the takeaway for this? You know, what are the implications? What are you left thinking after this ruling came down?
This is one of those cases that has real-world, practical, day-to-day significance for employers, for litigants alike. The second part of the Supreme Court's ruling set a standard for the level of deference or the level of review that judges will have on the EEOC's conciliation efforts. But because now a federal judge can review those efforts, the EEOC's behavior, the way in which it establishes its strategy, the way in which it interacts with employers, well knowing that someday the light's going to be shined on those activities, that ought to have a wholesale change and impact on the way the EEOC goes about its litigation enforcement business. So I would expect going forward that the EEOC's behavior and its interactions with employers will be much different. On the employer side, it means that probably you'll be able to have much better information and a sense from a risk management standpoint of should I settle or should I litigate based on what I'm facing. Before, the EEOC many times would not even reveal the basis of its theories, how many claimants on behalf it was suing, and basically just said take it or leave it. I think those days are over.
Interesting. And, you know, of course, as you guys have documented at Seyfarth, the EEOC has been very, very active in recent years. So it's going to be very interesting to see exactly how this plays out going forward. And you know, as you suggest, this could change things quite a bit. Once again, that was attorney Jerry Maatman. He's at Seyfarth Shaw. For more of his insight, you really can't find any better than what they have to offer. Be sure to visit the Workplace Class Action blog. It's at workplaceclassaction.com. Thank you for joining me today, Jerry.
Thanks, Colin. Have a great one.